For more than 150 years, we've lived with the understanding in America that the Constitution guarantees U.S. citizenship to everyone born in this country. That is the concept of birthright citizenship. And yet, one of President Trump's first moves upon taking office on January 20th was to issue an executive order declaring that citizens whose parents aren't citizens or permanent residents would no longer be citizens themselves. The executive order faced a wave of court rulings blocking its enforcement. Now it appears to be destined for Supreme Court showdown. If the legal proceedings up to this point are any indication, history is going to play a pivotal role in this case's outcome. For that reason, we brought together three of the leading historians of United States history to help unpack the historical dimensions of birthright citizenship. My name is Kareem Creighton. I'm the Vice President for the Brennan Center's Washington, D.C. office. We'd like to thank our partners from the Organization of American Historians and welcome their members who have joined for this conversation. Before we get started today, we got to do a little housekeeping. The Brennan Center is a nonpartisan law and policy institute that works to repair, revitalize, and to defend our systems of democracy and justice so that they work for all Americans. While the Brennan Center cannot support or oppose a candidate for office, we can, and as we always do, we will offer you today a vigorous debate about the policies and positions that matter for our democracy. We do this, of course, with a commitment to civility. If you post rude or inappropriate language on our message streams, you're going to be removed from our conversation. Just don't do it. There is going to be live closed captioning that is going to be provided for this conversation. And finally, we know that you have a lot of questions. We ask that you submit them via the chat, and we'll answer as many of them as we can in about the last 20 minutes of our program. Speaking of our program, let's get to who's on tap for today. Our guests, as I mentioned, are not just experts of the history of citizenship with award-winning books to boot. They also are critical authors of critical amicus briefs that lay out vital history for the courts to consider. So let me introduce you to them. We start with Martha Jones, the Society of Black Alumni, Presidential Professor and Professor of History at Johns Hopkins University. She is the author of Birthright Citizens, A History of Race and Rights in Antebellum America, and most recently, The Trouble of Color, an American Family Memoir. Joining us also is Kate Mazur. She is a member of the Brennan Center's Historian Council on the Constitution and the John D. MacArthur Professor and Professor of History at Northwestern University. She is the author of Until Justice Be Done, America's First Civil Rights Movement from the Revolution to Reconstruction, and most recently, Freedom Was in Sight, a graphic history of Reconstruction in Washington, D.C. In addition, we have Erica Lee, the Bay Family Professor of History and Radcliffe Alumnae Professor at Harvard University. She is the author of America for Americans and, most recently, Made in Asian America, A History for Young People. And rounding off our panel today, our very own Thomas Wolfe, the Brennan Center's Director of Democracy Initiatives and founder of the Historians Council on the Constitution. Good afternoon to each of you. Thank you for joining us and welcome. Now, with that out of the way, let's get to some questions. And we'll start at home with my colleague, Tom. Tom, we're going to ask you to set the stage for us. Help us to understand the executive order that I referenced earlier. What was it trying to do? And give us, if you will, an overview of some of the legal challenges that have followed in response to the executive order.
Thanks, Kareem. I'm happy to kick things off. As you flagged right at the top of the hour, the Trump administration issued this executive order just a few hours after inauguration, which kind of immediately escalated this issue to an emergency one. There's some legalese in the executive order, but essentially it denies American citizenship to children who are born in the U.S. to parents who aren't citizens or legal permanent residents. And to carry out that directive, the order bars the federal government from issuing documents that would recognize the American citizenship of children who fall into that category. So what we're thinking about there mainly is like the Social Security Administration denying Social Security numbers to children that are born under those conditions. Now, this order is deeply illegal. It violates laws in about 5 different ways, at least. It violates a common law rule that dates back more than 4 centuries. It violates the text, purpose, and spirit of our 157-year-old 14th Amendment, which says on its face, and this is really critical, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The order also violates a 127-year-old Supreme Court case, Wong Kim Ark, and subsequent cases. It violates an 85-year-old federal statute, and it violates more than 100 years of executive branch practice. All of these sources of law add up to one simple principle. If you're born here, you're one of us. And of course, the president can't change a constitutional rule, which makes the order a shocking executive overreach. It's the latest iteration of a longstanding project of undermining inclusion and representation, a project that the first Trump administration carried out through initiatives like the travel bans and the census citizenship question. So there's no doubt, that this is a major civil rights issue for our time. And it's also a major struggle over the future of American identity and our collective definition of what it means to be American. I think thankfully, as Kareem flagged, the pushback on this has been swift. State attorneys general, civil rights organizations, and immigrant rights groups filed lawsuits almost immediately after January 20th. There are now 8 cases pending around the country, which have generated several court rulings that have effectively blocked the executive order from moving forward for the time being. That's critical because if the order were allowed to move forward, it would wreak havoc. It would deny citizenship to countless children born from here on out. It would immediately place those children in the status of a kind of legal subclass where they'd be denied rights and protections that normally come standard with being born here. It would expose them potentially to deportation to foreign countries where they never lived and could face severe danger in. It would create administrative nightmares as governments started to try to figure out how to determine who's a citizen and who's not when they can no longer rely on the main thing that we use to figure that out, which is birth certificates. And of course, once the government starts requiring certain people to demonstrate their citizenship, everyone's going to be subject to that kind of inquiry. And so in that way, you can't really cabin this problem to our non-citizen neighbors. This is something that's going to spread and affect us all. The DOJ appealed all of those decisions, and they're now in front of appellate courts all around the country. Those courts are expected to weigh in on what we'd call the merits question of whether the order is legal. In the interim, the DOJ also took an appeal to the Supreme Court, and the court heard argument in mid-May on that, basically about the scope of these judgments that are protecting us right now from the order. We're not expecting the court to rule on the merits issue, but it's this court, so we'll see.
Thanks for that landscape view, Tom. As you mentioned, courts are going to be thinking a lot about how to understand the history of this. As you know, all of you all know that the history of birthright citizenship dates back even more than just at the time the words were written into the Constitution. I wonder, Kate, can you talk a little bit about that vintage history of the concept of birthright citizenship? Where did this idea come from that sort of gave rise to the language in the Reconstruction Amendment? And how did courts talk about it in the country's early days?
Sure, thanks so much. Yeah, I mean, Tom mentioned that the executive order kind of contradicts hundreds of years of common law tradition, and that's the case. The United States, at its founding, inherited a practice that had been present in the British colonies of North America, a practice of understanding that people born in the realm were considered subjects of the realm. So before the nation existed as a republic, before they really thought about things in terms of citizenship, there was a British common law tradition that understood that anyone born in the realm or the domain of the sovereign was a subject of the sovereign. And this came up in many different ways in kind of British history. It was a principle that the British colonists imported into North America. It's sometimes called jus soli, which means right of soil. It means that the citizenship of a person or the subjecthood of a person is associated with the soil, the territory on which they were born. which is often contrasted with the idea that citizenship and belonging are associated with blood or inheritance. So one is an idea that where you are born is what matters most. That is where you belong. The other is more associated with the idea that it is your background, it is potentially your race, it is your family that it creates citizenship. So at the time of the founding of the United States, the US Constitution didn't say anything actually about who was considered a citizen of the United States. It mentions the term citizen a few times. One of the most significant was where in the place in the Constitution where it says that the president of the United States has to be a natural born citizen or a person who's a citizen at the time of the founding. And that term natural born citizen, as many people understood at the time and in subsequent decades, was an allusion to that tradition, common law tradition of the idea that if you are born in a place, you are naturally a citizen of that place. Going forward, as the United States kind of unfolded in the first several decades of United States history, it really, the question of who was a citizen and how one became a citizen really was being worked out. And there were a lot of different venues in which this question was addressed. One of them was in the antebellum courts, and courts, to the extent that courts took up this question, both federal courts and state courts, they almost always affirmed this principle of common law birthright citizenship. So it didn't matter to them that much that the United States Constitution didn't explicitly say we have adopted the common law tradition, because they understood that that's what they had done. And so historians have shown that there are, quite a number of state and federal court decisions that affirm the common law idea that anyone born in this country is a citizen of this country. But at the same time, there was also a broader political discussion about who was a citizen. And citizenship unfolded not only as a federal matter, but also at the state level. And so in the course of the first several decades of the 19th century, some state governments affirmatively stated that free Black Americans, let me backtrack. The question of the citizenship of free African Americans became a kind of pointed question. So when the court cases that I mentioned were cases involving the children, the status of the children of people of European origin. And so these were the cases that came forward, and the courts had decided that the children of people of European descent or descent of people from the British Isles were citizens. But the question of the citizenship status of free Black Americans was something quite different. And so states gradually took positions on this, with some states affirming that free African Americans were citizens of their states, and other states essentially denying that. And that included southern states where slavery was legal, and even some northern states that had progressed toward abolishing slavery, but nevertheless denied outright or implicitly denied that free Black Americans were citizens. And we see this, another way that we see this kind of growing controversy, but also a tendency among white Americans to deny the citizenship status of free Black Americans, was through something called the American Colonization Society, an organization founded in 1816, led by some very elite white Americans who had the theory that free African Americans could never actually really be citizens or belong in the United States. They created an African colony in, it's called Liberia, now the country, independent country of Liberia. And they went around urging free African Americans to leave the country and undermining the sense of belonging and sense of citizenship status that free African Americans might have had. Sometimes by saying they were truly Africans, they could never really be Americans. And so that created a sense that Black claims to state or national citizenship were very tenuous.
Thank you for that, Kate. And I know, Martha, you and Kate worked together on an amicus brief that detailed a lot of the history leading up to the 14th Amendment. And of course, one element of that antebellum period was the infamous Dred Scott decision. I wonder if you could help us track some of that history, perhaps within that antebellum period that led to the entrenchment of the commitment to birthright citizenship in the 14th Amendment, particularly as it related to African Americans, how that informed the story.
Kate has begun to talk about the American Colonization Society as one locus for the struggle over who Black Americans are, free Black Americans are, and what their relationship is to the nation and to the Constitution. The ACS is committed to preserving the nation as a white man's country, their words, not mine. And what that means is that they intend to not only see through the end of slavery, but to ensure that Black Americans will make no claim on the nation. They will be removed by force, by coercion, by persuasion. And this is the project of Liberia and other West African colonies. So this is a pressure on free Black Americans from the early 19th century forward, but it's not the only pressure. Free Black Americans are also confronting what we come to call Black laws, laws that regulate their everyday lives, how they work, how they worship, whether they can travel, whether they have charge over the raising of their children, whether they will have access to schooling or other public resources. Black laws are a second instrument in the sorts of pressures that are not only persuading Black Americans that they might in fact want to choose to self-deport to a place like Liberia, but that they might look to the questions that, again, Kate alluded to. Who are we before the Constitution? And they become, despite being excluded from formal law study, being excluded from the bar, being excluded from office holding, free Black Americans begin to study documents like the Declaration and the Constitution. They are very compelled by that provision that requires the president to be a natural born citizen. They say, if there is such a category, why aren't we natural born citizens like the president? There's no color line in the Constitution. And so we see that they are building a series of arguments, a set of interpretations about citizenship in the United States that has a kind of urgency for their own lives. They hope that citizenship will permit them to resist the force of colonization, resist the force of Black laws. But of course, the questions they're asking are questions that have implications for all persons born in the United States, not only for Black Americans. Now, many of us, I think, if we studied citizenship at all, probably were introduced to the question by virtue of Dred Scott versus Sanford, which is an 1857 U.S. Supreme Court case. And part of what Kate and I have emphasized in our brief is that Dred Scott is a relatively late salvo from the High Court in a long-standing, much debated dispute about whether or not the birthright principle extends to free Black Americans. Justice Taney, as we know, notoriously holds that Black Americans have not been and cannot be citizens of the United States. But of course, he does so in the face of a well-developed set of arguments that Black Americans have been making in their newspapers, have been making in their political gatherings, what we remember as the colored conventions, a kind of shadow political movement that creates a platform for Black Americans who are otherwise excluded from the State House and from courthouses. Taney is responding to those sorts of claims, to that dispute, and looking to, in a sense, resolve it. Now, part of what we know is that Justice Taney doesn't resolve that. Even those of us who study Dred Scott, when we read the dissents in that case, understand that there was indeed a disagreement within the very court itself about the question of citizenship. Justices Curtis and McLean pen important, extensive, learned refutations of Taney's view. Black Americans, of course, will return to their conventions and other venues and continue to articulate the birthright principle and make their case, looking to win allies in the politics of the time, in the courthouses of the time, in the legislatures of the time. And this is the table setting, if you will, for the Civil War era, and now the opportunity for the new Lincoln administration to rethink this long-standing debate about citizenship. The first salvo will be in 1862, when Attorney General Edward Bates will pen his own opinion and affirm much of what African Americans have been arguing for decades, that not only is birthright the law of the land in the US, but that birthright extends to free African Americans.
Very helpful. I want to see, and I appreciated that how you discussed the point about African Americans thinking not only about their own experience with the law and the treatment of citizenship, but how they were also keeping in mind that the rule, once adopted, was going to apply more broadly. And for that, I want to talk a little bit with Erica, if you would mind. I'd love to hear the way in which that move, once Congress builds into the 14th Amendment the concept of birthright citizenship, how did that affect the large and fast-growing immigrant population in the United States? You've written a lot about that period. What was birthright citizenship's most significant impact for immigrant groups?
So first of all, thank you for inviting me to be part of this panel. I love being in conversation with my friends and colleagues. We wrote our amicus brief separately, but I think when we are part of this conversation, we can see the most important connections. And for me, that is the relationship between the systemic discrimination targeting African Americans and anti-immigrant xenophobia that is growing in the 19th century. So the fight over birthright citizenship is directly related to growing immigration in the 19th century. It is part of a larger effort to restrict immigration. And I think we can see these direct through lines to what is happening today. In the 19th century, it is immigration from China that is really sparking this debate. It's important to note that while Americans were engaged in really vociferous and even violent debates over Irish Catholic immigration, there was never any serious discussion to limit or end birthright citizenship for children born of Irish Catholic immigrants. That changes with the arrivals of, honestly, small numbers of Chinese immigrants in the big picture of immigration to the United States, but which gave a sort of outsized, had an outsized impact on American politics. Chinese immigrants were commonly compared to African Americans as imported slaves or coolies, persons racially unfit to become US citizens. Laws limited Chinese immigration beginning in 1862, again in 1875, and then in 1882, Congress passed the Chinese Exclusion Act. This is the first federal law to single out an immigrant group for immigration restriction. It also affirmed the whites-only naturalization laws that had been in place in the United States since 1790, and it led to successive legal attempts to restrict immigration from Japan, Korea, South Asia, and eventually the Philippines. We have to understand this as a multi-pronged approach on the part of the US government and on the part of many Americans to first restrict immigration, second, to expel Chinese immigrants, Asian Americans who are already in the United States, and then, as we see, to not only ban naturalization rights to Asian immigrants, but also then to take away birthright citizenship to children born in the United States of Asian descent, as part of this long ongoing debate over birthright citizenship. It is not until 1952 that the United States ends its decades of discriminatory laws that precluded Asians from becoming citizens as part of naturalized citizens. And this is why the right of birthright citizenship that was affirmed in the 14th Amendment is so incredibly important for immigrant groups like Asian Americans who had no other way to fully participate in the American political community as equals. And this is one of the reasons why the amicus brief that I contributed to on behalf of the Asian Law Caucus, the ACLU Immigrant Rights Organization, and the NAACP is so important, not just for Asian Americans, but for all Americans.
Thanks for that. And I have to say, for both briefs, what I appreciate is how the spotlight is turned in a different direction from the conventional story of Reconstruction to some of the communities who are directly affected by these words. Each of you talk a lot about the agency, the activity each of these communities that you explore are doing to try to influence that language. I want to turn to Martha to ask the question that kind of links the two as I see it. What do we know from the historical record about the work and the writings of the Reconstruction Amendment's founders, the 14th Amendment? What do you think that we know about their intentions in framing the birthright citizenship commitment and how it should be used or not used to have effect on immigrant groups? It was a hot button political issue. Do we have evidence that they saw these things as linked as we now do? Oh, and you're on mute, so let's try it. Yeah.
There we go. Yes, they did. And importantly, members of Congress who are debating and crafting the terms of the 14th Amendment are aware, I would say, intently and acutely aware of not only the question of how far and to whom birthright extends, but they are aware that it may in fact extend to immigrant Americans. This is part of their deliberation. And we understand when we look at the language of the 14th Amendment itself, it is the language of all persons. And for me, I like to contrast this to the work that Congress does just a bit later in 1870, amending the Immigration and Naturalization Act, which up until this point had provided a bar. Only white persons could naturalize and become U.S. citizens. Well, Congress could have taken the word white out, but thinks very deliberately, I think unfortunately, but deliberately, and adds to white, African, and persons of African descent in a direct move to continue the exclusion of, as Erica Lee has pointed out, the exclusion of Chinese immigrants from the possibility of naturalization. So it's to say we understand that Congress is not only aware that there are immigrant Americans from many places across the globe who will be impacted and affected by this affirmation of birthright citizenship, but Congress also has the ability to draw fine distinctions when it saw fit, and it does so in 1870, but declines to do that in 1868.
Now, Erica, you brought us in your comments into the 20th century and how the question about immigrant communities and their space and understanding how birthright citizenship affects them continues to be a political matter. I'm hoping you might be able to give us some other of, as you would identify, important legal developments that help inform the way we think about immigration being tied to this question about birthright citizenship that we're currently dealing with now.
Right. So just as Martha was explaining, the congressional debates provided evidence that Congress did intend that the 14th Amendment would grant citizenship to all US-born children, including the children of Chinese immigrants. But what happens is that as the United States continues to pass restrictive immigration laws and continues to push for what we would call today the self-deportation of undesirable immigrants and their US-born children, anti-immigrant activists seek to question and to overturn the 14th Amendment's guarantee of birthright citizenship to certain US-born children of those quote-unquote undesirable immigrants. And this is where we get to a man named Wong Kim Ark. He's born in 1873 in San Francisco to Chinese immigrant parents. Under existing US naturalization law, his parents, who were longtime San Francisco residents, cannot become US citizens. But because of the 14th Amendment, Wong Kim-ark is a birthright citizen. He is living with his parents in San Francisco. It's a period of enormous anti-Chinese, anti-immigrant violence. And in 1890, his parents they leave California for China. His parents remain there, but Wong Kim-ark returns to California. He is readmitted into the United States with no problem. He's recognized as a native-born citizen, readmitted into the US. He resumes his work in San Francisco. In 1894, Wong Kim-ark again goes to China on a temporary visit to see his parents, to get married. And at that time, we're about 10, 12 years into the Chinese exclusion era. And while the number of Chinese immigrants has decreased dramatically, there are still people who are coming to the United States. There's still people returning as returning residents, and anti-immigrant activists do not like this. So they're seeking another way to make it even more inhospitable in the United States for Chinese immigrants and Chinese Americans. And they settle on birthright citizenship. So Wong Kim-ark becomes a test case. He re-enters the United States, or he tries to re-enter the United States in 1894. He's denied re-entry in San Francisco. He's detained on the grounds that he is not a citizen of the United States. Immigration officials argue that because his parents were ineligible for naturalization, that he has essentially inherited their political status. He's detained in immigrant detention for 4 months. And this is where we see the legacy of African-American struggles for citizenship blending into the ongoing fight for equality amongst Chinese Americans. Wong hires lawyers. They take the case to the federal district court in Northern California. They argue that the 14th Amendment has guaranteed birthright citizenship for him, that he was born within the United States under the power and protection of the United States. And the judge in the Federal District Court of Northern California rules in his favor. The US government appeals that court decision, and the case goes on to the Supreme Court. And that is where Justice Horace Gray writes the majority opinion, joined by 6 other justices. They reject the government's argument. They affirm that the 14th Amendment does apply to native-born citizens of the United States, regardless of the immigration status of their parents. And this is one of the key parts of what is the government's executive order decision right now, as well as the many challenges that are arguing against it.
Thank you for that. Kate, I want to turn to you to try to pull some of this together. We've gone over a lot of historical terrain, and each of you all have nicely lifted up a truth that race, at least in part, informs a lot of this conversation. But I'm interested in your helping us to tie some of this all together. As you're seeing this, as you all historians typically like to do, making ties between present and past, is there something that we can say that we have learned about the historical record and how it helps us understand the fights that we are in the midst now of trying to figure out with respect to birthright citizenship? Are we seeing old threats rear their heads again? Are there dangers in what this conversation looks like right now that we need to be concerned about?
Thank you for that. I guess one thing I would like to do to try to unite some of these threads is really mention the inclusive vision of the framers of the 14th Amendment's Birthright Citizenship Clause. Reconstruction and this whole period is often misunderstood. It's not oftentimes in schools and wherever else, people don't get much of a chance to really study this period. And yet this period right after the Civil War is front and center for the history of birthright citizenship, and therefore for us now. And what the framers of the 14th Amendment were doing, and let me just underscore, they had lived through and were very well aware of Black Americans' antebellum struggles for citizenship. They had seen the ways that the kind of universalizing principle of birthright citizenship that the United States had supposedly inherited from England was undermined by white supremacists, by people who wanted to deny the birthright citizenship status of free Black people. The Republicans of the Reconstruction era were very aware of that. They mentioned those struggles during congressional debates. They wanted to put the United States on a new footing, but in the respect of birthright citizenship, what they were really doing was codifying in the Constitution, constitutionalizing, right, this principle that they believed should have been the guiding principle throughout United States history to date, the principle that had been abrogated by people like Justice Taney and others who denied the citizenship of free Black Americans. And so they were challenged, right? There were questions within Congress. Well, does this apply to the children of Chinese immigrants? Does it apply to essentially the children of people who themselves would not be permitted to naturalize? They said, yes, it does. We are doing this and it applies to everyone. I'll just briefly mention that there were widely acknowledged very small exceptions to the birthright citizenship tradition coming out of the common law. And they were mainly that the children of foreign diplomats residing in the United States and the children of invading armies were not considered to be birthright citizens, but that everybody else was, right? And so the people at the time in Congress, they acknowledged that. And so the notion of subject to the jurisdiction thereof is a reference to that. And it is not a reference to the notion that the children of some immigrants or some persons who are not able themselves to naturalize or might be temporarily present in the United States are not citizens. That's not what subject to the jurisdiction thereof was about, and that's widely acknowledged. So I think that one of the dangers right now is that in putting this executive order out, and let's keep in mind that undermining the constitutional principle of birthright citizenship has been a goal of some Americans for quite a long time, right? So the Trump administration is not pulling this out of nowhere, but they're really trying to bring to a head something that some factions have wanted for a very long time. One of the dangers is that people begin to confuse the history, that people are sort of taken in by these arguments that, oh, well, it really never was that firm of a principle. It was never a very universalizing principle. Oh, certain people who aren't here or aren't here permanently or what have you, like their children are not included in this. These are arguments that the Trump administration and their allies and the people who are sort of theorizing on their behalf are putting forward to kind of, let's suppose that they believe what they're saying, but what they're really doing is muddying the water. They're pulling a quote here and a quote there, and really not telling the full story. So I think one of the dangers is that people get taken in by this sort of idea that there's more ambiguity than we may have previously have imagined in this. And the truth is that I think historians will agree there's not ambiguity in the aims of the framers of the 14th Amendment and what that generation was trying to do. But the reality is also that, as Erica Lee and Martha were saying as well, there have always been people who wished that was not the American principle, right? Who wanted birthright citizenship to go away.
So I want to remind everyone that we have questions that we'll make sure that we ask that you post. I'm going to ask our comms team to send me a text with the questions because I'm not seeing them on the screen. But while you're thinking of that, I'm going to ask Tom the last question before we turn to audience questions. You mentioned earlier, Tom, that there are a lot of courts across the country who are grappling with this right now in live litigation, particularly about the enforcement of the executive order. Can you give us an update on where things currently stand and what we need to expect next as they move forward?
So there are sort of two big pieces going on right now. One is the Supreme Court case that I mentioned. It's been covered in the press as sort of the birthright citizenship case. It's not quite what's going on there. I mean, it comes out of those cases, but what is happening there is DOJ is asking the Supreme Court to weigh in on two related issues. One is whether we can keep having what they're calling nationwide injunctions, and also whether the state should be allowed to sue on behalf of their people to address constitutional violations like the ones we're seeing here. DOJ is arguing there essentially that district court judges shouldn't be allowed to block the government from moving forward with the order in places outside those courts' jurisdictions, and that judges shouldn't be able to extend the protections of their rulings to people who aren't parties to the case. So we're waiting for the Supreme Court to rule on that issue, and we should get that ruling before the court ends its term at the end of June or early July, basically before the justices go on summer vacation. Theoretically, that ruling won't address the legality of the executive order. Meanwhile, the appellate courts are teeing up rulings on that question of legality, the constitutional merits of the executive order. The Ninth Circuit had argument in this in early June and should rule at some point in the early summer after the Supreme Court issues its ruling. We'll also see oral arguments in the Fourth Circuit in September and the First Circuit a little later. So you should expect to see this issue recurring in the headlines over the second half of the year. Now, there are, I think, obvious reasons to be skeptical about how these cases will play out in the grand scheme of things. But what I really want to underscore is that even this court is going to have an extremely difficult time ruling in DOJ's favor and somehow undermining birthright citizenship. I think, as our guest showed today, history is firmly on the side of the challengers to this executive order. The judicial rulings blocking the order around the country have been uniform in condemning the unconstitutionality of the order. And the law and the Constitution are very clear on this. And there's just one thing that I want to really emphasize that I think comes out of what Kate was saying about what the framers of the 14th Amendment were really up to when they framed out the 14th Amendment. And the idea was to constitutionalize the issue, to take it out of the flow of day-to-day politics so that in some manner of speaking or another, our rights change based on the political winds. And so these arguments that are attempting to carve out exceptions to birthright citizenship or argue that it should be narrowed in some way or another are kind of completely missing the overall point of the 14th Amendment, which was to take us out of these kinds of policy arguments once and for all, and to place a rule that's universal that will apply to everyone going forward, kind of regardless of how things turn out from election to election.
All right. Thank you for that, Tom. And I want to start with questions from our audience that relate to the litigation that's currently being managed in the federal court system. And I'm just going to start here with a question I'm going to pose to you, Tom, just to get a broad sense of things. The one question we get is, when you said that the Supreme Court heard an early version of the argument about birthright citizenship, a procedural question, did the Supreme Court justices seem receptive to the government's case at oral argument to defend the executive order?
You know, I'm a good appellate attorney, so I try not to actually predict the outcome of cases. But what I will say from listening to the oral arguments is that I think that the justices who put this issue up, you only need 4 votes actually to take a case up to the Supreme Court, may have had a little bit of a dog catching the tire of the car moment. I think the understanding was that they could use a case like this to rule once and for all about whether there could be nationwide injunctions. In order to do that, you sort of need to bracket the actual subject matter of the case. But when you start thinking about, as the justices clearly started thinking about during the course of the oral argument, what it would mean to allow the Trump administration to move forward with this executive order in some pockets of the country or with respect to certain groups of people while the rest of the litigation played out, I think they realized that they may have bitten off more than they could chew. And so I'll be very curious to see how the court ultimately rules in this case, but I do think that there was a little bit of regret that may have come from maybe an incomplete understanding or appreciation of really what they were taking up when they took this case up.
So I want to ask this next question to Erica, and in part because you had a lot to say about the pushback on the initial commitment to birthright citizenship, particularly in the 20th century. The question is, and maybe others will have thoughts about it as well, do the arguments against birthright citizenship have support among any legal scholars, or are they considered legally essentially fringe theories?
They used to be considered fringe theories. Kate, I think, was the one who mentioned that efforts to raise the question about automatic birthright citizenship to children of undocumented immigrants has long been a subject and a desire amongst many in what was then considered the far right or extreme right. What I think is different about the executive order is how broad it is. This is not just questioning automatic birthright citizenship to children of undocumented immigrants, but also to anyone who doesn't have permanent legal residence. So that includes temporary visitors, it includes international students, it includes refugees, asylees, et cetera. This is one of the reasons why the organization, the Asian Law Caucus, raised this issue in the amicus brief, because Asian Americans will be disproportionately impacted by this order. If I could, I'd love to also answer another question that's in the chat, which is, could a reinterpretation of the Citizenship Clause or a approval of the executive order impact the citizenship status of groups that were previously denied citizenship? And
you anticipated where I was going, Erica.
Oh, good. I'm so glad. I wanted to draw from the lessons of history in showing that even raising this question to this level as part of an executive order has led to what Tom alluded to at the very beginning, de-Americanization, the destabilization of American citizenship for all of us. I talked a lot about Wong Kim Ark, whose Supreme Court victory in 1898 is a landmark constitutional case that affirmed birthright citizenship for all persons born in the United States. He actually benefited very little from the Supreme Court case. He made subsequent trips to China. Every time he tried to re-enter the United States, he had to go through exhaustive immigration interrogations. At one point, he was even arrested by immigration authorities on the charge that he was in the United States illegally. He eventually left the United States and never came back in the 1930s. And we see how these questions of who is an American through birthright citizenship challenges, but also through anti-immigrant xenophobia, has led to the de-Americanization of entire communities. We saw this during the Great Depression when Mexican Americans were forcibly removed or greatly encouraged to self-deport. We saw this during World War II when Japanese Americans were incarcerated. In both cases, during the Great Depression and during World War II, 2/3 of those who were impacted, meaning deported to Mexico or incarcerated in concentration camps during World War II, 2/3 were American citizens, mostly very, very young children.
I wonder, Martha or Kate, have you any additional thoughts on the question that Erica nicely queued up? What the impact would be on other populations like African Americans and Native Americans. And then also, I wanted to at least throw out there the broader question about whether or not there is an after. If the Supreme Court decides that this is the government's position is correct and the president has authority to declare it no longer applicable to groups, is that something that might have impact on people of color for whom at least we know the 14th Amendment at least had in mind when the framers adopted it?
I can jump in, Kate. One of the things that I think Erica Lee's comments invite us to underscore is that much of the questions that roil through the lives of Black Americans before the Civil War, through Chinese immigrants and their children after the war, and beyond into the 20th century, that most of that is not in the hands of high courts. Most of that is not subject to the kinds of careful, deliberate scrutiny and review and reasoning that we are focused on in this moment. That much of what happens in the lives of Americans when citizenship is brought into question, when de-Americanization becomes part of the landscape, is that those decisions about whether or not you are a citizen, you appear to be a citizen, you should be regarded as a citizen, will be in the hands of very low-level public officials. We will meet them at the border, and they will be TSA agents who will size us up. We will meet them on the streets, and they will be agents of ICE who judge us to be looking like citizens or not looking like citizens. This is what we know is possible from the 19th century because figures like Wong Kim Ark and so many, many others experienced this kind of scrutiny, not in the high court, but in their everyday lives. And this is the kind of harrowing context that the abrogation of birthright, as has been proposed by the Trump administration, the abrogation of birthright has already, as we see, right? We need only turn on our news to appreciate how harrowing the streets and the schools and the churches and all of our venues of public life have become, not because the Supreme Court is thinking about those venues directly, but because petty officials are now empowered to ask the question, does this person appear to be a citizen of the United States?
I want to throw out this question to anybody interested. This is a question that actually gets to the question about how this might be utilized, a decision that eats at the question about birthright citizenship, how that might be utilized by other public officials. Is the attack on birthright citizenship at all connected to the executive order requiring proof of citizenship to register to vote? Tom, I'm going to start with you since I think you've been thinking about these questions as well. But like, is there a connection between the two, or should we be concerned about there being made connections between the two?
I think we need to constantly be concerned about that. And I think that, as our guests today helped show, questions about who is a citizen and the sort of political ends that excluding people or including people can serve have been on the agenda for hundreds of years. Eric and I separately, with other hats on, had talked about the history of the census in the past and things like citizenship questions. And there is kind of a ongoing project that is extending through a lot of parts of American political life that is designed to undermine representation for people of color in the United States and people from immigrant communities. And one of the number one wedges to do that is to make citizenship a highly relevant legal category to extend rights and retract rights, include people and exclude people. And then versions of that problem kind of emerge wherever they can be useful. And so you see attempts to exclude non-citizens from the census count. You see attempts to exclude non-citizens from the apportionment bases or the redistricting bases when it comes time to draw lines, layering in additional requirements to prove your citizenship in order to vote. It creates a situation very concretely, like Martha was just warning us about, where when you start layering in all of these additional documentary proofs of citizenship, you're empowering bureaucrats to sort of decide for themselves who looks like they should be included or who looks like they belong, who can prove their belonging. And that is the gateway for all kinds of discrimination and also power stripping.
Thanks for that, Tom. I'm going to bring our Q&A to a close with one last question, with thanks to each of you for offering such deep and I think thoughtful commentary on the work that you've done and how it affects this big question that courts are still grappling with. I'm going to ask each of you this question in a few sentences, and we have a few because we have little time. What's the one thing that you would want our audience to walk away from this conversation with this afternoon? Let's start with Erica, and then we'll follow with Martha. Erica?
I think it's just worth underscoring something that a few of us have said already, and that is that this is all connected. Even if this executive order is overturned or dismissed, there are ongoing fights, challenges to citizenship, to the freedom to move, to what it means to be an American and what rights we have both inside and outside of the United States. And so I just urge everyone to stay aware and to understand the interconnected aspects of this one battle as part of a larger war.
Martha, to you.
You know, what's afoot in this executive order is, in my view, a betrayal of the 14th Amendment. The 14th Amendment was a grand democratizing transformation in our understanding of the national body politic. It was intended to include people, to bring them into this nation fully. And it is now being perverted, wielded as a weapon to exclude people, something the 14th Amendment never intended to do.
All right. And Kate, I'd love to hear your thoughts on that.
Yeah, I think we want to avoid getting sucked into the idea that this history behind the 14th Amendment is more complicated than you might think. The history shows that that's just not the case. The aim of the Citizenship Clause of the 14th Amendment was to constitutionalize a universal, expansive vision of who is an American citizen. It's a very democratic, small d democratic, and inclusive vision. And the aim was to put it in the Constitution so it would be out of the reach of politicians who come and go, and to make it a bedrock principle that undergirds who is an American. And I think there's a very straightforward, very clear case that is what the Birthright Citizenship Clause was intended to do, and we should keep that in mind. And I would encourage people to really go deep in history if they're interested in this question, and if people don't believe the kinds of things we've been saying here today, please read history and get back to us. Thanks.
Be sure to read their books.
Yeah, but maybe read other books too.
Absolutely.
I'll just say, like one thing that we've been talking about is that history is complicated and history is contentious, and history doesn't only speak in one voice. And so, to kind of believe that this one line from here or this one line from there really is all we need to know is just, that's not the case. And that's why I'm saying, we should go deep.
Fair enough. Tom, bring us home. What are our takeaways from today's conversation?
Well, in addition to reading the briefs that our guests filed in these cases, I will say that as I've been making the rounds advocating for birthright citizenship, I think very many people have been receptive to the call. But there are a few people who in this current environment still ask this question of, well, what's the point of saying this is what the Constitution means or this is what the history says if the administration is just going to do what it wants anyway? Here's the point. The surest way to protect our Constitution is to act like we still have one. The surest way to lose it is to act like we don't. Speaking truth to power still works in this moment. Our guests today, when they stand up and they speak out and they provide facts to the courts, they're equipping the courts to have our backs. I think it's very important to have their backs and to spread the messages that they're giving us, because it's by spreading that knowledge, establishing expectations about what the Constitution gives us and what we deserve, that we protect our rights and continue to move them forward.
Wise and poignant words, Tom. thank you to each of our historians for showing us really that we've been here before and that there are high stakes in this conversation about birthright citizenship. Thanks to our audience for all of your really important questions. I'm sorry we couldn't get to all of them, but we got to a lot. I want to just say in closing, remember the Brennan Center is looking forward to seeing as many of you as possibly can joining us at future events. To be the first to know about when events are announced, be sure to sign up for our newsletter. You can find it at brennancenter.org/events. Once again, thanks so much to our cast of wonderful experts today. And thanks again to all of you for coming. Have a great one.